The Supreme Court has a great deal of power over lawmaking in the United States. Yet there are many judges and scholars who believe the Supreme Court should simply decide cases and leave policymaking to Congress. They argue that judicial restraint is necessary to prevent the court from creating and changing policies that affect the lives of Americans. Judicial activists want just the opposite. Activists believe the court should use its power to make bold policy decisions, to correct policy errors that are responsible for social and political injustice, even to break new constitutional ground. Those who believe that judicial activism is necessary often point to the landmark civil rights case, Brown v. Board of Education of Topeka. They say that state legislatures and Congress had been slow to create policies that prohibited discrimination and segregation. Judicial activists argue that without the intervention of the court, it would have taken the nation much longer to emerge from segregation. Proponents of activism also point to the protection of other civil rights. They argue that without the court advocating for the accused, that the poor, the illiterate, and minorities would be falsely imprisoned. In contrast, those who favor judicial restraint argue that the Supreme Court has no constitutional basis for legislating, that judges possess no special background or qualities that make them experts in the areas of social, political, or economic reform, that because judges are appointed, not elected by the people, they are not directly accountable to the people. Historically, Supreme Courts exercising judicial restraint have avoided becoming involved with controversies. Becoming overly political has been such a concern for the court, in fact, that it developed the doctrine of political question. The doctrine is cited any time the court determines that an issue should be left entirely to another branch of government. Whereas an active court rarely employs the doctrine, a restrained court uses it frequently.
There is hardly a political question in the United States which does not sooner or later turn into a judicial one. Alexis de Tocqueville, 1835.
One of the Supreme Court's more important functions, perhaps the most important function, is to oversee the system-wide elaboration of federal law with an eye toward creating and preserving uniformity of interpretation. Indeed, the most commonly enunciated reason for granting review on a case is the need to resolve conflicts among other courts over the interpretation of federal law. Sandra Day O'Connor.
Judicial review, the Supreme Court's primary tool in the system of checks and balances, empowers the court to determine the constitutionality of government actions. It also makes the court the final authority on constitutional interpretation.
It is emphatically the province and duty of the judicial department to say what the law is. John Marshall, 1803.
Throughout American history, the Supreme Court has overturned more than 150 acts of Congress, from Marbury v. Madison in 1803 to U.S. v. Morrison in 2000, as well as more than 1,200 state laws. Most overturns have involved civil liberties incorporated through the 14th Amendment. Consequently, most have also occurred during the 20th century. The 2000 Bush v. Gore decision, for example, when the Supreme Court determined the winner of the disputed presidential election. Judicial construction is similar to judicial review, but has a singular concern. How strictly should the Constitution be interpreted? Loose constructionists who believe that the Constitution is a dynamic, living document do not bind themselves to the original intent of the Founding Fathers. They instead take their cue from portions of the Federalist Papers.
The interpretation of the laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning as well as the meaning of any particular act proceeding from the legislative body. Alexander Hamilton, June 14, 1788.
For further support, loose constructionists point to Article 1, Section 8 of the Constitution. Specifically, the General Welfare Clause, stating the government's duty to provide for the general welfare of the United States, and the Necessary and Proper Clause, empowering government to make all laws which shall be necessary and proper. Strict constructionists argue just the opposite, that the Constitution is a static document that should be followed to the letter. They would have all interpretation of the Constitution base itself on the literal meaning of its words or adhere to the original intent of the founders. Interestingly, strict constructionists also point to the Federalist Papers.
There is not a syllable in the plan under consideration which directly empowers the national courts to construe the laws according to the spirit of the Constitution, or which gives them any greater latitude in this respect than may be claimed by the courts of every state. Alexander Hamilton, May 28, 1788.
It is important not to confuse views on construction and judicial activism with liberalism or conservatism. Although these terms have taken on very different meanings within the context of American politics, a general definition of liberalism is the openness to change, while conservatism is the desire to retain the status quo. Different Supreme Courts have been perceived as displaying a personality, how justices within the court approach the issue of activism and construction. Individual justices' views differ. A court as a whole, however, can exhibit liberal or conservative tendencies. The Earl Warren Court of the 1950s and 1960s, for instance, exemplified a liberal viewpoint, held a loose constructionist philosophy, and frequently exercised judicial activism. Conversely, just a few decades earlier, the New Deal Court of the 1930s had been very conservative, balking at New Deal legislation and supporting strict construction. Today, the debate over loose or strict interpretation of the Constitution continues. Strict constructionists desire certain predictable law. Those opposed counter that certain phrases of the Constitution are too vague to determine original intent, or the Constitution's literal meaning for that matter. Technology and diversity, critics say, have changed the needs of the nation in ways the founders could not have imagined.
In Federalist Number 78, Alexander Hamilton observed that of the three branches of government, the judiciary will always be the least dangerous to the political rights of the Constitution. Hamilton also declared that the judiciary is beyond comparison, the weakest of the three departments of power, that it can never attack with success either of the other two. Opponents of judicial activism would argue that Hamilton was, at best, overly optimistic and at worst, naive. Some believe that the Supreme Court, and by extension the federal judiciary system, have the capacity to endanger both the rights of citizens and contravene the power of the legislative and executive branches of government. Do you believe that the Supreme Court has become too powerful? What if you knew that within the first 15 years of the Supreme Court's existence, it demonstrated the capacity for limiting the power of the presidency and Congress and intervened in the presumed rights of individuals? In the case of Marbury v. Madison, Chief Justice John Marshall established the Supreme Court's power of judicial review, allowing the court to affect legislation and determine whether acts of Congress or the executive branch are constitutional. Knowing this, do you believe that the Supreme Court is too powerful? What if you knew that the Supreme Court has struck down legislation that the majority of people, as well as the other branches of government, supported? In 1998, the Supreme Court defeated a broad line-item veto authority that Congress had given the President to cancel specific items in spending and tax bills. Knowing that the court has the power to nullify legislation that the rest of the system of government supports, do you believe that it is too powerful? What if you knew that many of the court's most activist decisions have actually been in favor of protecting and expanding the rights of citizens? When state legislatures and Congress had been too slow to create policies that prohibit discrimination and segregation, the court ruled in the case of Brown v. Board of Education of Topeka to expand the rights of citizens by prohibiting racial segregation. This ruling extended the rights of white Americans to black Americans. Understanding that many of its most activist decisions have been used to expand individual rights, do you believe that the Supreme Court is too powerful? The Supreme Court has the power to affect the daily lives of Americans. While some believe that the court is too powerful and has the potential to take away the rights of citizens and limit the power of the other branches of government, others disagree, claiming that the court works to uphold and expand individual political rights and avoids making decisions that limit the power of the other branches of government. Despite the arguments for judicial activism or restraint, the Supreme Court remains the supreme law of the land and the final authority on the Constitution.